সকলকে আবারও আমন্ত্রণ ক্রিমিনাল জাস্টিস প্রোগ্রাম দেখবার জন্য। আমি আজাম কো সলিসিটার্স এর প্রিন্সিপাল সলিসিটর শাফিউল আজম এবং আমার সাথে আছেন আমার কলিগ ডেভিড ওয়ালব্যাংক কিউসি। এই যে কেয়ার হোম বসের যে জেলখানা দিয়েছে, ওখানে যে ক্রাউন কোর্টের জাজ উনি বলছিলেন, হোয়াট ইজ টেরিবল is to have to sentence a 69-year-old woman of previous good character, he said. সে বলছে কি যে এটা খুব টেরিবল যে একজন 69 বছর বয়স্ক মহিলাকে যার কোনো প্রিভিয়াস কনভিকশন নেই, একটা প্রিভিয়াসলি গুড ক্যারেক্টার, তাকে আমার এই সাজাটা দিতে হচ্ছিল। এবং জাজ বলছেন কি, বাট I remind myself you did terrible things, কিন্তু আমি আমাকে স্মরণ করাচ্ছি যে তুমি খুব টেরিবল থিং গুলা তুমি করেছো, তুমি খুব মানে ভয়ঙ্কর কাজগুলো তুমি করেছো, যে তুমি ছিলা তার ইয়ার্স এন্ড আইস সবগুলা তাকে হেল্প করেছো, চোখ কান খাড়া রেখে তাকে ওই যে ওদের পয়সাগুলো হাতিয়ে নেওয়ার জন্য তুমি বসকে হেল্প করেছো। Over a 16-year period from 1997 to 2013, he groomed 6 wealthy and vulnerable residents who were mostly recently widowed women before draining their bank account, said prosecutors. যে পুলিশের যে প্রসিকিউশন ডিপার্টমেন্ট আছে, পুলিশের যে সিপিএস বলা হয়, ক্রাউন প্রসিকিউশন সার্ভিস, তারা বলছিল কি যে সে উইডো উইমেন, যা বিধবা উইমেনদেরকে তাদের পয়সা করি সে মানে চিটিং করে তাদের কাছ থেকে নিয়েছিল এবং তাদের ব্যাংক অ্যাকাউন্ট ড্রেইন করেছিল, তার মানে সব পয়সাগুলো তাদের ব্যাংক অ্যাকাউন্ট থেকে বের করে নিয়েছিল বিভিন্ন কায়দা কানুন করে। The court was told he isolated victims from family and previously trusted acquaintances and got them to sign over control of their finances. সে তাদের পরিবারের যে সদস্য তাদের কাছ থেকে আইসোলেট করেছিল, বিচ্ছিন্ন করেছিল ভিকটিমদেরকে, এবং তাদেরকে আপনার ইনফ্লুয়েন্স করেছিল এবং মেক শিওর তাদের কাছ থেকে সাইন করার জন্য তাদের মানে ফাইন্যান্সটাকে কিভাবে কন্ট্রোলে নিতে হয় তাদেরকে দিয়ে ডকুমেন্ট সাইন করাইছিল। যেটা আমি আগেও বলেছিলাম আর গত সেগমেন্টে, he had a fleet of luxury cars including Ferraris and Rolls Royces. তার লাক্সারি কার, ফেরারিস এবং রোলস রয়েস এগুলো তার সব সময় ছিল। এটা আপনার কোর্ট শুনছে। the boss যে তাকে he was convicted of 4 counts of conspiracy to defraud, 1 count of fraud, 3 counts of theft, false accounting, and transferring criminal property. He was disqualified from being a director for 15 years. তাইলে তাকে 4টা কাউন্টের জন্য তাকে কনভিক্টেড করা হয়েছিল, ওই মানে রেসিডেন্সিয়াল কেয়ার হোমের বসকে 21 বছর ক্রাউন কোর্ট জাজে দিয়েছিল, যেগুলো হচ্ছে কনস্পিরেসি টু ডিফ্রড, 1 count of fraud, 3 counts of theft, false accounting, and transferring criminal property. David, quite serious offenses for which he was convicted. Now, just if you can explain the viewers the difference in conspiracy to defraud and the fraud.
Yes, okay. Well, I don't want this to become a law lecture for your viewers, but I suppose that the main way, the easiest way of explaining it is probably to say that the offence of fraud, as now contained in the Fraud Act of 2006, is very closely and carefully and clearly defined by statute. whereas the offence of conspiracy to defraud is, I suppose the fairest way of putting it is to say it's rather vague and general, because it's not contained in an Act of Parliament. It's what's called a common law offence, which has been created, if you like, by judges over the decades and the centuries. So if we just take them each in turn, fraud on the one hand and conspiracy to defraud on the other. I mean, the offence of fraud is slightly unusual because it's obviously a very important offence in any system of criminal justice in any country. And it just so happens that in our country, in England and Wales in particular, it underwent fairly fundamental changes in a relatively recent statute in 2006, the Fraud Act of 2006. And I'll sum it up very briefly. There are essentially three different ways in which the main fraud offence under the Fraud Act 2006 can be committed. Fraud by false representation, fraud by abuse of position, and fraud by failing to disclose information. Three different ways of committing the same offence. And in each instance, the prosecution have to show not only that the defendant was guilty of the conduct which they allege, the false representation, the abuse of position, or the failure to disclose information, but they also have to show in each instance that it was done for a very particular purpose. It was done for the purpose of either making a gain for himself or herself, or for the purpose of causing a loss to another person, or for the purpose of exposing another person to the risk of loss. But subject to that, the definitions in each instance are fairly wide. So a representation can be express or implied, very, very wide definition of representation. Abuse of position covers a multitude of sins, and failure to disclose information can actually cover any failure to disclose any information which the defendant is under a legal duty to disclose to the victim and withholds from the victim. But although it covers a multitude of situations, pretty closely defined either by the statute or by case law decided thereunder. By contrast, conspiracy to defraud is much more difficult to pin down. Not, as I say, set out in an Act of Parliament. It's a common law offence, and I don't think I'm going to attempt to try to describe the elements of conspiracy to defraud, because we really will descend into a law lecture. But what I will say is that it covers an array of situations, a multitude of situations, and it is criticised by many lawyers. In fact, the abolition, the repeal of the offence was recommended by the Law Commission at the time that the Fraud Act 2006 was under consideration, because it was felt to be too wide-ranging and too vague and too general. But the main criticism is that the essential feature of it is dishonesty. And if somebody can be shown to have been dishonest, then the prosecution have gone a very long way towards establishing their allegation of conspiracy to defraud. I think that's probably the fairest and briefest way in which I can put it for the purpose of your viewers.
Yeah, we will come back to some other information about this case. The victim, a widow, had 1.4 million pound stolen. এই মহিলার কাছ থেকে 1.4 million pound হাতাইয়া নিয়েছিল এই বৃদ্ধ মহিলার রেসিডেন্সিয়াল হোম থেকে। এবং যে বস, কেয়ার হোম রেসিডেন্টের বস, টার্গেটেড multimillionaires Katie and Gordon Wiley, hiring a life coach and psychic consultants to make spells to banish their family. That means make a spells to banish their family. যে সাইকিয়াট্রিস্ট আপনার কনসালটেন্ট এনগেজ করেছিল, লাইফ কোচ, এবং তাদেরকে তাদেরকে বিভিন্নভাবে মানসিকভাবে তাদেরকে বুঝাইয়া সুজাইয়া তাদেরকে ভ্যানিশ করে দেওয়াটা মানে একটা খেদাইয়া দেওয়া তাদের ফ্যামিলির থেকে তাদেরকে বিচ্ছিন্ন করে দেওয়া, নির্বাসিত করে দেওয়া, আমাদের বাংলায় যেটা বলি আমরা, যে তাদেরকে একদম নির্বাসিত করার জন্য এই ট্যাকটিক গুলো সে ফলো করছিল। He made a fraudulent claim for 10 million pound he said was owed to him after Mrs. Wiley died. ওই মহিলা মিসেস উইলি যে আপনার আপনার মিলিয়নিয়ার, যে সে মরার পরে তার কাছ থেকে সে বলছে যে আমি পাই 10 মিলিয়ন পাউন্ড পাই। জেনারেল ম্যানেজার যে ছিল 69 years old, 69 বছর বয়স্ক, convicted on 11th of May following a 12-month trial, 12 মাসের ট্রায়ালের পরে, the longest in the history of Merseyside Police and Liverpool Crown Court। যে পুলিশ বলছে কি এটা মার্সিসাইড পুলিশের এবং লিভারপুল ক্রাউন কোর্টের জন্য এটা ছিল একটা লংগেস্ট কেস ওই সময়। আপনার সবার জন্য ট্রায়াল হয়েছিল। bookkeeper মানে অ্যাকাউন্টেন্ট admitted fraud and false accounting and was sentenced at 8 months in prison, suspended for a year. Bookkeeper David, just if I come back to you again, bookkeeper was convicted for false accounting. Just tell briefly so that our viewers can understand what is that false accounting. That is a different terminology than the fraud.
It is. It's very, very specifically defined. I think rather than trying to summarize it, I'll just tell your viewers how it's defined as a matter of law. It is the offence is made out where a person dishonestly, with a view to gain for himself or another, or with intent to cause loss to another, destroys, defaces, conceals, or falsifies any account or any record or any document made or required for an accounting purpose, or alternatively, where that person dishonestly with a view to gain for himself or another, or with intent to cause loss to another, when furnishing information for any accounting purpose, produces or makes use of an account or a record or a document which to his knowledge is or may be misleading, false, or deceptive in a material particular. It's a bit of a mouthful, I'm afraid, Shafi.
Yeah.
And not at all easy for your viewers to follow, I fear.
Yeah.
But that is an example of an offence in English law which is very precisely defined, and I fear that any attempt that I make to try and reword the definition is actually going to make it less clear rather than more clear. But it's basically using accounting documents for accounting purposes in dishonest and deceptive ways. I mean, that's a very rough definition, but it's a specific type of dishonesty in relation to accounting documents for accounting purposes. I hope that makes some sort of sense to your viewers.
Now, this 42 years দর্শক যে bookkeeper সে তাকে দেওয়া হয়েছিল 8 months prison এবং suspended for a year. David, why it seems shorter sentence? Why the sentence was short for him?
A very much shorter sentence. If you look at David Barton's sentence of 21 years from the judge, albeit reduced to 17 years by the Court of Appeal, and Rosemary Booth's sentence of 6 years, and Korea Hughes, the bookkeeper, as you've said, ultimately received a suspended sentence. There are two main reasons for that. The first was that she pleaded guilty. She didn't have to stand trial. She didn't put the prosecution and the jury to the trouble of having to hear evidence and decide the case in relation to her and decide whether she was guilty. She admitted her guilt, and that always gains a defendant a significant discount on their sentence if they plead guilty, and it's a sort of descending scale. The earlier in the proceedings that you plead guilty, the bigger the discount that you get on your sentence. But the other factor, and this was really the crucial factor in her receiving a much shorter sentence and ultimately a suspended sentence of imprisonment, which meant that she didn't go to prison immediately, and indeed she never would go to prison so long as she stayed out of trouble after that. The key thing was she not only pleaded guilty, but she offered to and did give evidence for the prosecution against the other defendants in the case. And as your viewers can imagine, that can be incredibly valuable to the police and to prosecutors if they can call evidence not only from victims and from other witnesses, and call evidence of I don't know, bank statements about transactions and wills that have been made, making David Barton the beneficiary of a will, and powers of attorney and all the other sort of documents which they would ordinarily place before the jury. But your viewers can imagine what an enormous difference it makes to a prosecution, and how much easier it makes for the prosecution to prove what's happened if they have an insider, if they have an inside man or woman who admits their guilt and says, I am prepared to not only plead guilty, but I will give evidence for the prosecution. I will go into the witness box and I will tell the story as I knew it from the inside, and tell the jury exactly what happened as I knew it, and tell the jury about the roles of all the different people involved. That's enormously valuable evidence from a prosecution's point of view. And it always leads to a very, very substantial discount in the sentence that's passed on the defendant concerned. And I'm confident that that is the main reason why Kariah Hughes, the bookkeeper, received a so much shorter sentence than her co-defendants David Barton and Rosebery Booth.
Finally, your concluding remarks in this very important case, if you can have about another 3 minutes, please.
Okay, well, I'll see what I can do. We've been focusing mainly on the facts of the case because it was a very interesting case factually. As you've said, longest ever case, I think, in terms of the trial investigated by the Merseyside Police or tried at the Liverpool Crown Court. A very serious and complex trial, and interesting facts, but also legally a very important case. And it's a case that will be referred to by lawyers and by judges for, I suspect, decades to come. And the reason for that is it did two very, very important things. It made two very important changes in the English criminal law. First of all, it gave the Supreme Court, which is now the highest court in the land, the opportunity to redefine what is meant by dishonesty in the English criminal law. And it also, to an extent, and to an important extent actually, redefined our doctrine of precedent. Now, your viewers probably won't be familiar with that word, but precedent is the set of rules which lay down the extent to which a judge hearing a case now, and even the Court of Appeal and other appellate courts dealing with the case now, are bound by previous decisions of judges in earlier cases. It's very technical, and the doctrine of precedent is governed by very specific and sometimes rather technical rules. And I don't think it's putting it too high to say that the Supreme Court in an earlier case, and then the Court of Appeal in this case, virtually tore up the rules of precedent, or at least they substantially rewrote the rules of precedent in this case in a way which is going to be very important to lawyers for years to come. If I've got time, I'll try and summarise the effect of it. In relation to dishonesty, until recently, the test was thought to be a twofold test. the jury had to apply their own view of what they thought would be regarded as dishonest by ordinary and reasonable people, but they also had to look at what they concluded the defendant himself or herself thought was dishonest. So it was both an objective test about what reasonable and sensible and ordinary people think, but also a subjective test, what did the defendant think. And the effect of this case is that the second part of that test has now unequivocally, unambiguously gone. There'd been an earlier Supreme Court case in which the Supreme Court had said, we think the second part of the test, which has been operated for the last 35 years, is wrong, and we don't think that courts any longer should apply the second part of the test, trying to work out what the defendant himself regarded as dishonest. But this case confirmed the position and has made clear to lawyers from now on there is no second limb to the test of dishonesty in the English criminal law. And as far as precedent is concerned, the reason that this case is so important is that the earlier Supreme Court decision, which I've mentioned, in which the Supreme Court has said we don't think that the second limb is correct, and as far as we're concerned, the second limb should not be applied in future. Strictly speaking, under the rules of precedent as they applied until this case, future courts making these decisions, because the question of dishonesty in that earlier Supreme Court case didn't, strictly speaking, arise for decision by the court. The court didn't need to decide what dishonesty meant, and because they didn't need to decide it under the old rules of precedent, that was regarded as probably a non-binding decision on future courts and future judges. Yeah. What this Court of Appeal decided was the rules of precedent have now been amended so that where the Supreme Court makes a finding, expresses an opinion that the law is so, and all the judges of the Supreme Court are agreed that the law is so, in effect that will now be binding on future judges and future courts, even if the Supreme Court didn't strictly have to decide that question on the case that they were deciding. So in terms, what the court found was, and I'll quote because it's better that I say what the judges found rather than me trying to summarise it, where all the Supreme Court justices in an appeal directed that an otherwise binding decision of the Court of Appeal Criminal Division should no longer be followed, and stated that an alternative test should be adopted, the Court of Appeal was bound to follow what amounted to that direction from the Supreme Court, even though it was on a question which didn't strictly arise for decision. And to that limited extent, the ordinary rules of precedent have been modified. So a really important decision in two respects.
Yeah. We are out of time now. Okay. দর্শক, আজ আমাদের সময় শেষ হয়ে গেছে। আজকের প্রোগ্রামটি আবার রিপিট দেখানো হবে, পুনঃপ্রচার করা হবে নেক্সট টিউসডে, মঙ্গলবার দিন দুপুর 12:30 থেকে 2টা। তাছাড়া এনটিভি ইউরোপের ফেসবুক এবং ইউটিউবে লগ ইন করলেও আপনারা প্রোগ্রামটি দেখতে পারবেন, এবং আজকের কেস সম্পর্কে আপনারা crimecast.law তে লগ ইন করলেও এই কেসের মোর ডিটেইলস আপনারা দেখতে পারবেন, যেটা ডেভিড ওয়ালব্যাংক কিউসি এই আপনার সাইটটা আপনার রান করেন, crimecast.law। আর তাছাড়া শাফিউল আজম, সলিসিটর শাফিউল আজম অথবা আজাম এন্ড কো সলিসিটরস এর মধ্যে যদি নাম দিয়ে যদি সার্চ করেন, তাহলে আপনারা আমাদের এই প্রোগ্রামের লিংকটা পাওয়া যাবেন। সবাই ভালো থাকুন, সুস্থ থাকুন, এবং সকলের প্রতি আমার শুভকামনা থাকলো। আসসালামু আলাইকুম।